It's Vijaya, and you've tuned into the Immigration Hour on Mirchi, brought to you by the NPZ Law Group, US and Canadian immigration representation for individuals, families, and businesses in New York, New Jersey, Indiana, Florida, Canada, and India. And joining me is Ludka Zimovcak, partner and managing attorney at NPZ Law. Welcome, Ludka.
Thank you, Vijaya. It's
So,
good to be
Ludka,
here.
great having you as always. And Ludka, we have a listener question for you. And this person asks, I have an EB-3 case. My child is turning 21 in a few months, and the Visa Bulletin is finally current, so we can file adjustment of status. But can you please confirm that my child will be safe?
Ooh, okay. This is a really good question.
Mm-hmm.
And I'm going to give you a lawyer's answer. It depends.
Oh.
There is a layer, there are a few layers that we have to talk about. So first of all, I'm hearing that the listener is saying finally current, which probably means that it is the filing date that is current. So there are, in the Visa Bulletin, there are two charts, final action chart, and then it's a filing date. So for the child, we do have Child Status Protection Act. I know we talked about it many times. So it helps children not to age out, for the green card purposes. So shortly, we call it CSPA. So generally speaking, CSPA will help, but final action date needs to be current. So that is the recent change that happened in August of 2025. Before that, we had a more favorable calculation of CSPA age, and that was using the filing date. So now this changes everything for our listeners. So if it is the filing date that is current, we cannot do calculation for the child. And unfortunately, I'm not sure if the child will be safe. So I'm just going to give you a few examples. How do we determine the CSPA? How do we do CSPA age and CSPA calculation?
Right.
So it all depends how long the I-140 petition was pending. So let's assume that the listener, there was a premium processing. So it only took 2 weeks to get approval. Then we only have 2 weeks that we can deduct from the child's age. So let's say the child turns 21 and now is 21 and 2 months when the final action date becomes current. We can only deduct 2 weeks. But if the I-140 petition was pending, let's say for a year, then we can deduct 1 year from the age. So let's say, again, in the same example, if the child is 21 years old and 2 months when the final action date becomes current, then, obviously CSPA age would work and child would be able to benefit and be safe, for purposes of adjustment of status. So with that being said, it probably is not the greatest idea to even file adjustment of status, because what could happen is, yes, it's possible to file it at this point, but what could happen is that the child will age out after adjustment is filing. And I've seen these cases and, it's devastating.
Yeah.
So, I would probably wait until the final action date is current, for the kids, for the child. And until we can be sure, or the listener can be sure that, child will be protected under CSPA. But another concern here would be, that CSPA doesn't work for non-immigrant status. So let's assume our listener is in H-1B status and dependent would be in H-4 status, right? So once the child turns 21, that's it. There is no CSPA for H4. So it's really important that our listener kind of thinks about what to do as far as the non-immigrant status. Typically, if let's say the child is pursuing studies and is in college, it's a good idea to change status, possibly to F1, to protect the non-immigrant status. And again, once later, priority date under final action chart will become current, then it would be possible to file for adjustment of status, assuming the CSPA calculation works out favorably. But at this point, it's very possible that the child will age out. And, it's very unfortunate, but this was changed, as I said, in August of 2025, and that's what it is right now. So in the future, this may change again, but at this point, it's very important that the child maintains non-immigrant status, perhaps waits with filing of adjustment of status until it is 100% that will be protected under CSPA. So while we have it, it's great protection, but it's not for everyone. And the CSPA calculation needs to be done properly.
Wow, thank you for elaborating on a very complex issue, I would think. But, hope is always springs eternal. So a little bit of a bad news, but thank you for clarifying that for us.
Of course.
And that's Ludka Zimovcak of the NPZ Law Group, your one-stop shop for all U.S. and Canadian immigration matters. Call them at 201-670-0006 and claim that discount off your consult when you mention Mirchi. More coming right up on matters of immigration, because immigration matters. So don't go anywhere. Keep it tuned to Mirchi. It's hot.